bill is presented to Parliament, that first, it encourages innovation in technology and encourages emerging expertise to be utilized in cybersecurity because of the emerging issues that we are having with technology. The bill must also meet the objective of incentivizing investment into the field of technology. If that bill is not meeting that objective, then it will be falling behind what is expected for this bill to meet. And this bill, from my thinking, must also offer a framework that attracts a lot of investments while taking into account a deliberate utilization of Kenyan human resource. Because we very well know that our young generation in Kenya are very suave in technology matters. They have advanced to a very good extent, and it would defeat purpose for us to create a law which doesn't take into account deliberate utilization of that human resource, the Kenyan youthful human resource that is very well versed in technology. I have looked at the provisions that are in this bill, and I want to join my colleagues, Senator Kathy, and I don't remember, there was another senator who also, I think it was Senator Authority, who also talked about the definition of a geographical area, controlled area. And there is also Senator Sigei who's spoken into it. And I'm looking at the definition section, the interpretation section, preliminary. That's on page, the first, I think it's page, I don't know why it's named as page 113. I'm looking at it and asking myself why Konza Technopolis was defined with specific reference, specific parcel of land, and with a specific geographical zone, with specific hectares, 2023.6. Supposing tomorrow, Mr. Speaker, supposing tomorrow Konza Technopolis needed double this space, or did not need this much land, and needed to utilize a quarter of this land, would it be smart to define that parcel, specific parcel of land, land reference number 9918/6? What is the purpose of introducing a specific? This is legislation. This is not a contract. You define acreage and you define area based on a specific contract between contracting parties so that it locks the subject matter of that contract. When I look at definition of Konza Technopolis, it's a bit, it's something that anybody would put in a schedule or in a regulation or in an annex document. Ideally, in law, you must create a principle which gives the parameters around which an issue is being enacted for a regulation or a rule. So I think it's a bad idea, and that must be amended. Then I've looked at the reference to the buffer zone, meaning a defined area surrounding a technopolis that is subject to controlled land use. When we talk of a buffer zone, it is not even defined whether it's now within this Konza Technopolis or whether that buffer zone will be taken beyond the 2023 hectares. It is not defined whether the authority, Technopolis Authority, will wake up one morning and define the buffer zone as a radius of, say, 1,000 hectares around the Konza Technopolis, and that leaves it vague and subject to abuse. I would say, first, when the buffer zone is introduced within this legislation, what is the purpose of that buffer zone? What is the size of that buffer zone? What does it intend to fulfill? Is it helping the Technopolis? Is it radiation? Is it subject to certain things that could be affecting the neighborhood? What is the buffer zone for? If you just throw words here, we know how our nation operates and how our people think sometimes. Some of them are not well-intentioned. They will misuse that area that reference to buffer zone to bring in demands on maybe the people who live around the Konza Technopolis, and it could be used wrongly by people who are not well-intentioned. So I would say, let the buffer zone be taken out. If it's not taken out, define the purpose of that buffer zone, the size of that buffer zone, whether the buffer zone is within the Technopolis area or whether it is not. And I give this submission while respecting the fact that ideally, this Konza Technopolis should not be defined the way it is. This doesn't look like good draftsmanship. Then, the definition of Konza Technopolis. Though I'm not an expert in IT, I'm asking myself, should a Technopolis dealing with technology, dealing with virtual spaces, should it be defined in a physical manner? Or do we define even virtual spaces where this technology will be utilized? Are they within, is this act applicable to virtual spaces? So I'm thinking there is just something not correct about that definition, and experts must be able to tell us, for instance, when you have a virtual space, do you own that virtual space? Are there rights that could help one to own that? If you leave those virtual spaces here, can you raise a claim against a competitor who comes in to use your virtual space? I see many times, Honorable Speaker, when companies like Safaricom host masses, they have satellites, they have masts. I see them having a joint cooperation with other companies in the same sector in communication, utilizing that space because of certain policies that you regulate, how even those spaces, even those aerial spaces can be utilized by companies to ensure that you're not spreading out certain parameters of uses of land that could be co-shared between even competitors. So when we see the definition of Konza Technopolis as actual land, is a mindset still in investment on physical property, physical tangible assets, physical immovable assets, or do we have spaces that are not seen, by bare eyes? So I see as though that is not very progressive. It does not take into account the utility of virtual spaces. And I believe this should be amended or removed from this revised and dropped. And based on whether virtual spaces should be included, then the definition must change. Then, Honorable Speaker, I have gone to Section 5 of this bill, and I have looked at 5(1)(b), and the powers that are given to, the functions that are given to the authority to allocate land to investors in a technopolis. From the plain reading of this provision, Honorable Speaker, this clause does not indicate whether there are any terms even for allocating that land. And indeed, as pointed out by legal experts who are also doubling in as senators, land allocation is something that is not within the purview of the Technopolis unless if they own it and they want to lease it, in which event they would say leasing the land or using different terms and concepts. Allocation of land is a function that is left to either the government, the Ministry of Lands, or county governments. They could allocate, but I'm not sure whether allocating land is a concept that should be used here. Maybe other definitions of how land could be, how land could be leased out, or other ways or licensing of that land by the holder of the title. And again, the provision leaves it very open. For instance, if this is enacted into law and it says that this authority shall allocate land to investors in a technopolis, it means all I would need to do when this turns into law, I would just walk into the offices of the Technopolis Authority and then demand that land be allocated to me. And because they have not put it subject to any conditions that may be developed by the authority, I would even say it's a free allocation. So if you try to put a premium on it or demand a consideration for that land as the authority, a person interested in that land or an entity interested in that land could easily challenge this in court and say it was an open allocation. So if they must allocate or lease out this land, that must be amended to read that based on the conditions that will be laid out by the authority. It has to be closed so that anybody transacting with that authority will understand that there are conditions that are developed. And then there is the concept within which this law has been made. If you read it, it's pointing at just the Konza Technopolis. How about the concept of this Technopolis being open to 47 other counties? So that we have a clause introduced in the bill foreseeing a situation where the 47 counties would have the freedom to also develop their own technopolis. And supposing already in one of the counties, say in Nairobi, they're already having an area where Nairobi County, where they have already developed a concept close to Technopolis. Can a clause not be introduced into this bill that then says those Technopolis which are already meeting the conditions under this bill will be recognized to be within the purview of this bill and will become subject to the authority? The land use in the Technopolis, there is defined in section 6 of this Technopolis Bill that the authority shall have all powers necessary for the proper performance of its function under this act, including the power to regulate land use in a Technopolis. So how far do you give this power to Technopolis, and why is the land use being regulated by Technopolis while in actual fact the zoning of land and land use is defined elsewhere, especially because there is an intention for that land to be allocated? I think this is an overreach and it needs to be redefined. That function could be resting elsewhere, not within the Technopolis. And if they must do it or give an advisory, they can only give an advisory to the organs or the entities that are legally mandated to deal with the land use planning. So my submission is that function rests elsewhere and should be left to the entity, the public entity that is supposed to deal with it. When I look at 6D, approve development applications, issue construction permits, and license users within a Technopolis. Of course not, they cannot issue construction permits. That once again is within the purview function. It's a function of the county governments. They issue construction permits unless they need a very technical construction permit whose expertise rests within the Technopolis. But there is no suggestion within this bill that they will have a team of experts in construction of premises suitable for matters that are required to be developed or technology that requires to be developed within the Technopolis. They have not brought in the element of very special expertise that cannot be handled by the county governments. And if they have not brought in the concept of experts who can come into these construction permits, that is not within their mandate. So it will be void, even on the plain reading of it. And they do not reference to any regulations that will be applied in licensing. Then I want to look at 6F. The authority has been given powers to enter, inspect, and search any premises to enforce the act. Is that not going against the Standard Policing Act? How will they enter? Do they have a policing unit? Is there a creation of policing unit? It's food for thought to the proposer of this bill. Let me go to the qualifications of the chair and under section 7. The chair seems to be a person qualified for appointment as the chair if the person is a citizen of Kenya, holds an undergraduate degree from university recognized in Kenya, has at least 10 years experience in leadership and management, and meets the requirements of Chapter 6 of the Constitution. I do not think those qualifications are adequate for a chair of such an authority. We must add another qualification, and an amendment must be done to this section to add that he must be a graduate qualified in a matter of technology, so that he's versed with what the authority is doing. Just bringing in somebody from, for instance, if you gave that authority to Professor Tom Ojienda, and we know what his expertise is in, would he be the best suited Kenyan to lead that authority? My proposal is it should be a person who is versed with IT or technology matters or communication matters. So, Honorable Speaker, in my view, a lot of work needs to be done, and a lot of work needs to be done to amend and revise these sections. This looks like an ordinary bill, one that does not go into the specializations that it is supposed to be addressing. So while the intention is good, it does not go into the specific technology area and bring out the salient, unique issues that need to be addressed within the Technopolis. And once again, the buffer zone of the Technopolis needs to be addressed. That concept of the buffer zone needs to be addressed. And then, Honorable Speaker, I've seen a section also requiring that processing of expatriates' permits, working permits, will be done by the authority. That also needs to be rethought. Processing of such permits would normally be done by the immigration, and entities that come to trade or invest must have the local content. They must have Kenyan within the purview of their human resource, so that if we have local skills that can serve within those companies, they must be included, and they must have a Kenyan local content included in any investments that come into the Konza Technopolis or into the Technopolis concept. With those many remarks, I support this, but subject to revision, to heavy revisions, to clean up and tidy out all those issues that have not been addressed, and to bringing the concept of technology within the bill, so it doesn't look like an ordinary bill